Here's what we should do about Roe v. Wade. All these states that want to have abortion on demand, no restrictions, you should just secede. Seriously, we should all just secede from this thing called the United States and go our own way because of Roe v. Wade. That would be fantastic. California can do its thing. New York can do its thing. Illinois can do its thing. I can be happy where I'm at here. I don't have to deal with your nonsense out on the left coast or in the Northeast, liberal Northeast. That would be awesome. And that's actually getting back to our roots. Talk about that all the time on this channel here. Because when we were founded, we were never founded as a nation. That didn't happen until the time of Lincoln. You had this fight between the Jeffersonians, the Lincolnites. But when we were founded, we were a confederation of states, a confederacy, because each state is sovereign and independent. And we should have never had a Supreme Court. If we were to have a Supreme Court, it should have been set, the highest level of the court should have been set at the state level. That would have solved 90% of what we're going through in this country right now, all this division. And guess what? They were talking about secession in 1794, on the day of the signing of the Constitution. The Declaration of Independence, people were talking about secession. The Hartford Convention, 1814, 1815, after the War of 1812. Now, I've seen a lot of people bring up the Dred Scott case, comparing it to what's going on with Roe v. Wade. Well, the Dred Scott case was completely different from Roe v. Wade. And I hate to call somebody out here who's very well known in the media. And Ben, I love you, man. You're very knowledgeable. I love watching your videos. Talking about Ben Shapiro, of course. The Daily Wire. He's very intelligent. And he's right on a lot of issues. But he was wrong in this video he posted talking about Dred Scott, saying that the reason that Dred Scott was denied his citizenship is because he was black. That's not the case at all. He was denied his citizenship because at the time, slaves and persons who had just been freed were not considered citizens because of the social structure, economic structure of the time. You have to remember that 19th century life was completely different than what we have now. And I've mentioned this many times before. Anybody who was a slave, a freed black, who was a free person, who was Irish, part of the lower British classes, Chinese, many of those people came to this country through indentured servitude. So they had to either buy their freedom, earn their status. They were considered nomads or vagabonds. I mean, that's just the reality of what was going on in the 19th century. So it affected everybody. Black, white, poor. Affected everybody. But the 14th Amendment was not modified till 1868. So up till 1868, which means during and just after the Civil War, before the modification of the 14th Amendment, these groups were still lumped in that same social and economic category. So I hate to correct you, Ben, on that, but your assumption of this is, or comparison is not correct. And the other thing, too, is Justice Taney. A lot of people say that he was biased, he had loyalties to the South. That may be true. But at the end of the day, he had to look at the Constitution as it was written at the time. And at the time, the Constitution did not prohibit slavery in the territories because it all came down to expansion in the West. Remember, you had the gold rush in 1849. I lived in Northern California, so I know something about this. In fact, one of the houses out where I lived was owned by a wealthy black man who made his fortune in gold. Very well respected in the community. You have a lot of stories like that. Don't hear about them all the time, and there's some books out there about black families that settled in the West. But the gold rush had a major impact on the expansion westward, as did the Louisiana Purchase. Of course, the Louisiana Purchase happened before the gold rush. But when they found gold in California, people started flooding out west because they heard all these stories of finding gold. In the town that I lived in, they had a huge reserve of gold that they could not get to because it was too hard to get to. Underneath the town, they could not get to it. But let's get back to Roe v. Wade. So once again, I'm not trying to pick on Ben Shapiro. Like I said, I have a lot of respect for him. He does a lot of great work here on YouTube. He's very knowledgeable. But he was wrong in saying that Dred Scott was denied his citizenship because he was black. No, he was denied his citizenship because of the social and economic structure at the time and the status in which slaves or newly freed slaves fell in alongside the lower English classes, the Irish, the Chinese, and the 14th Amendment not being amended or modified till 1868. Now, here's what happened with Roe v. Wade, because a lot of people believe that you had Jane Roe, which is the name that the court gave the person involved in this case, whose real name is Norma McCorvey. It's believed that she filed her petition with the Supreme Court. That's not what happened. In 1969, she got pregnant. Got it in my notes here, so let me go through this. Try to do some research for the video here. 1969, she got pregnant in She got pregnant in Texas, and she wanted to get an abortion, but it was illegal in her state. But it was legal if the mother's life was in danger. And you had attorneys Sarah Weddington and Linda Coffey, who sued on her behalf, claiming that the Texas law violated McCorvey's constitutional rights, right to privacy. A 3-judge panel ruled in her favor, but Texas appealed the decision with the Supreme Court. So these federal judges ruled in her favor, and the state of Texas turned around and took this to the Supreme Court. That's what happened with that case. But there were some issues with the decision that came down from the Supreme Court in Roe v. Wade. The biggest being that they did not set parameters for these states. Did not really define, okay, if we allow abortion in these states, what is the standard that has to be met with that? Yes, it is a woman's right to choose, but the courts, the states, they have to balance woman's health against public interest and the life of the child in the womb, prenatal life. So those factors were not included in that decision, and they should have been. And on that fact alone, the case should have been tossed out, should have been brought back to the state level. So we should just secede and let the states handle the issue of abortion. That's how this should be done. Now, here's what I think about abortion, okay? I think that abortion should be a last resort. It should not be used as a matter of convenience. If the mother's life is in danger or the child's not going to survive in the womb, in the case of rape or incest, then yes, I think that that should be an option, but a last resort when everything else has failed, with multiple opinions by different doctors. And parameters should be set in these states of what that bar should be so everybody benefits. There's a way you can do it without infringing on somebody's right or a woman's privacy, which, by the way, there is no right to privacy in the 14th Amendment. I've gone through it. I've picked it apart. There's no clause or anything in the Constitution that would guarantee a right to privacy. Yes, you have a right to be secure in your property, your papers, because a man's home is his palace. But this is what happened with Roe v. Wade. The fact that the Supreme Court made this decision that, yes, it is a woman's right to choose. It's her body, but we have to weigh woman's health against what's in the best interest of the public. There's a moral responsibility there. But they really didn't define the guidelines for these states to follow. Downfall of Roe v. Wade. Now, in 1992, you had Planned Parenthood, looking through my notes here. You had Roe v. Wade being modified because of the case of Planned Parenthood versus Casey. And now you have this case that dates back, I believe, to 2013 in Jackson, Mississippi, which is Dobbs versus Jackson Women's Health, where the court is reviewing the constitutionality of the 2013 Mississippi law that prohibited abortion operations after 15 weeks of pregnancy. And so people involved in this case in Mississippi are claiming that the Mississippi law violated the ruling in the Planned Parenthood versus Casey, which allows a woman to have an abortion within the first 24 weeks of pregnancy. So they had oral arguments about this in December of last year, 2021, and they're still working on a final decision, which should come out, as these decisions usually do, sometime in early or late June. So I hope you enjoyed the video. If you did, you know what to do. Culture Confederacy saying peace out. Stay safe, everybody. God bless this great country. Thanks for being with me, letting me stumble through my notes here. But if we want to solve this issue with Roe v. Wade, states should just go their own way. California can do what it wants to do. Illinois can do what it wants to do. I'm happy where I'm at. We can still share a common interest, the same currency. Getting back to our roots, states are sovereign and independent. Because no two states are alike. And these, surprisingly, were the same arguments people were having in 1794 as they were in 1814, 1815, as they were in 1860, 1861. I mean, how much power should the federal government have? We're seeing this now with this issue of free speech, with this disinformation czar. Can you cry fire in a crowded theater? Everybody knows that you shouldn't. A lot of people say, you can't cry fire in a crowded theater. Well, maybe we should. No, but that would cause, that would cause a lot of pandemonium. You know, people can get hurt that way if it's a false claim. And then when you have something really happen, it's like the boy who cried wolf. So we have laws set up in this country for slander, libel, and rightfully so. We saw it with Liberace and this article that came out that claimed that he had attacked a worker at a hotel. But there were no witnesses that were interviewed. No sources for that story. I think that came in Confidential magazine or something. It actually, his lawsuit against that magazine brought that magazine down. Because they had no basis for the story that they put out. So yes, there has to be certain guidelines for speech. Just like there should be certain guidelines for abortion. But if California wants to do its own thing, let it do its own thing. That's all I'm saying. So thanks for being with me. Don't want to rant too much longer, but I'll catch you next time. Once again, Cultural Confederacy saying peace out.